On behalf of the Board of Governors, welcome to our member town hall. Today's topic is the Practice of Law Board's Legal Technician Rule. I want to welcome everyone who's here with us in Seattle in person. There are a number of people who are joining us from all over the state via our webcast, and so welcome to those folks who may be from as far away as my hometown of Spokane. I'm Nancy Isserlis. I'm the third-year governor from Spokane and also serving as the treasurer this year. With me is Doug Lawrence, who is a shareholder at Stokes Lawrence in Seattle. Doug was on the Board of Governors a few years ago from 2005 to 2008 when the Practice of Law Board's Legal Technician Rule was being debated and proposed to the Supreme Court. Doug's going to take about 15 or 20 minutes this morning to present an overview of the history of the rule and a summary of the arguments pro and con, for and against, and the Board of Governors' formal position that we have had for about the last 3 years. In June of this year, the Supreme Court is scheduled to take action on the Practice of Law Board's proposed legal technician rule, more recently known or now known as the Limited License Practitioner Rule. The purpose of this town hall meeting is for the Board of Governors, and there are a number of my fellow board members in the room here today, to hear from our members and for the Supreme Court to hear feedback from our members and others who might be impacted by the rule. I want to get a couple of just slight housekeeping issues. I have my own personal teleprompter. It's wonderful. Some housekeeping issues out of the way. We need to keep a record of who's here. We have a list of who has signed up. Please make sure, if you haven't done so already, to sign in at the registration desk so we know who is attending today. For the people who are online, your login is your sign-in. Either use your username or the guest login. There are people in the back of the room who are moderating the webcast participants. Please turn off your cell phones. I turned off mine. If you don't have a copy of the rule, there are printed copies out front if you want to follow along and read along. I don't anticipate we're going to be having any breaks in this unless this goes really long. If we do, I just want to let you know that the room isn't secured during any breaks, so take your valuables with you. The restrooms are down the hall. You can read the instructions on the door on how to get there. Since this is being recorded, we've set up a podium with a microphone. We'll be only taking comments and questions from the microphone at the podium because we need to be able to make sure that the folks who are listening on the webcast can hear and see everything. So if you have a comment, I'm going to ask you to come up and make those comments from there. If you have any written comments or something that you would like to submit that will become part of the package of information that we will make available to the court, please, I guess you can just come up and hand it to me, and I'll keep it for safekeeping and make sure it gets to the right place. I'm not sure how many people here are going to actually have anything to say, but I think for purposes of making it fair to everyone, I'm going to ask that you limit your comments to 3 minutes. I could probably be a little flexible on that. If you have something in writing that you'd like to hand up, please do that as well. The input from this town hall will be made available to the Supreme Court. The recorded broadcast will be posted on the on the WSBA website on Monday. So if you're here and you want to watch it again, please feel free to log into the web on Monday and see how that looks. So we have some latecomers, so come on up and make yourselves at home. I would like to introduce some people in the front row. So if you would just stand up and turn around and say hi to the people in the back so we make sure that the folks in Spokane and Wenatchee can see your faces. Steve Crossland, who's the president of the WSBA, is not here. He is not here for a very good reason, because he's stuck on an airplane someplace beyond his control. He had every intention of being here. This is a very important event to him and to our organization. If he sneaks in at the last minute, well, I'll make him feel welcome, but he may not make it, but I'll make sure he watches the webcast on Monday. In addition, we have Paula Littlewood, who is the executive director of the Washington State Bar Association, Nick Burning, chair of the Practice of Law Board, and Julie Shanklin, who's our assistant general counsel and the Practice of Law Board administrator. So at this point, I'm going to turn it over to Doug Lawrence, who has some comments and a little history lesson for all of us.
Great.
Yes, Justice.
Is there a way for anybody who's on the
If I could get you to move the microphone. Thank you very much.
I just wondered if there's a way for anybody who's on the webcam to talk
yes.
to you.
In fact, there are written instructions that those who are on the web see it on their screen. They can either send their comments to, there's 3 people in the back who will take those comments. If the person wants those comments read at the podium, we can make arrangements to do that. If it's longer than, I think, 40 words or something like that, we're asking people to actually send their comments to an email address where that we can have them printed off. So folks who are on the web have a lot more instructions than we have here. So they're well taken care of, but thank you for asking the question. All right, Doug.
Okay, thank you very much. As Nancy mentioned, I was on the Board of Governors from 2005 to 2008. Those were kind of the nascent years for this rule. I think the first thing I want to emphasize is this is a rule that was submitted to the court several years ago in 2008. It still is before the court. The WSBA has taken its position. That position has not changed, and we will take that. This forum is to give you an opportunity to provide any additional comments that you may have, certainly to the WSBA, but really the comments go to the court because it is now the court that will make the decision about this proposed rule. I thought a good place for us to start would be to refresh our understanding or a recollection of what is the proposed rule, APR 28. The proposed rule is a rule that establishes a framework to allow non-lawyers to perform certain activities that would otherwise be considered the practice of law. The structure of the, I'll call it the arrangement or organization, is such that, first of all, at the top of the pyramid, just like with lawyers, you have the Supreme Court. They are all subject to the control, supervision, and direction of the Supreme Court. Underneath the court, there will be established a board called the Limited License Practitioner Board, or we're just talking in terms of legal technicians, it's the same animal. And that board is under the rule to be composed of 13 members. 9 of those members will be attorneys at law admitted to practice in the state of Washington, and there will be 4 non-lawyer members. The primary job of that board is to oversee the operations of the legal technician program, but very important, and I want to emphasize this, it will be the board who will come up with recommendations for areas of law in which the legal technicians may work. And I say it that way to make sure everyone understands that the rule as proposed does not identify or focus on any specific area of law. We'll talk a little bit in the history about the fact that there was a time when there was some discussion about how would this apply to certain areas of practice, but the rule that the court is considering does not focus on any specific practice area. Now, what happens for an individual to be able to become a legal technician? What do you have to do to be qualified? We've got the structure for how this operation will be supervised and administered, but to be a legal technician, there are certain baseline requirements. First of all, you have to be 18. That's a good idea. Next, you have to meet character and fitness requirements, just like for lawyers. So there'll be similar character and fitness requirements for any individual who wants to be a legal technician. There are certain educational requirements under the rule. Either the person needs to have a bachelor's or associate degree in paralegal or legal assistant studies, and that must have been issued through or obtained through an approved school, and they must have, in that case, 2 years of actual experience as a paralegal or a legal assistant acting under the supervision of an attorney. As an alternate, you can get a bachelor's or a post-baccalaureate certificate from an accredited school, an approved school in paralegal or legal assistant studies. And if you go that route, then you need to also have 3 years of experience as a paralegal or a legal assistant under the supervision of an attorney. And in all cases, within the 2 years before you actually sit for the license, there is an exam we'll talk about briefly, You also have to have 20 hours or more of pro bono legal services of a nature to be defined by the board. So those are the educational and experiential requirements to be able to become a legal technician. You also need to take an exam similar to the bar exam, I will say. I'm sure it will be different as our bar exam has morphed, but nonetheless, you will have to sit and you will have to pass an exam that will include questions with respect to the rules of professional conduct, and there will be rules of professional conduct that apply to legal technicians. It will also cover rules of privilege and confidentiality, because those rules also apply to legal technicians. And then also, of course, substantive law. So whatever substantive law is approved for practice by legal technicians, someone wanting to practice in that area has to pass an exam to prove a certain level of competence in that substantive area of law. Now, once you are a legal technician under the rule, you have to meet certain annual requirements as well, similar to practicing lawyers. You have to pay a licensing fee. You have to meet certain continuing education requirements, and you have to provide proof of your ability to respond in damages. So it's basically you need errors and omissions insurance or some other bonding to show that you can make someone whole if something goes awry. As far as the kinds of activities that a legal technician would be able to do in their interactions with clients, they are required in all circumstances to have a written agreement with the client. That written agreement must state, first of all, that they are not a lawyer, that they are a legal technician. It must set out the standard on which they will charge fees. It must state the type of work that they will be performing for them. And then they can, when they're perfecting or they're actually doing their job as a legal technician, they can only do certain things. They can, under the rule, obtain information to help with the question at hand. They can inform a client about applicable procedural matters that relate to their specific circumstance. They can provide self-help materials that have been prepared by Washington attorneys or approved by the board, so not something they can create themselves. It has to be something that the board has already approved and attorneys have participated in the preparation of. They can review documents and exhibits and explain them to the client. They can select and complete approved forms. So similar to LPO, you have to have an approved form to be able to use it as a legal technician. They can perform legal research and draft letters and documents, but only if those documents, letters, etc., are reviewed and approved by a Washington lawyer. They can advise the client about other documents that may be necessary in the client's matter. So depending upon the area they're working in, as we all know, when you do X, you may then have to do Y, or to perfect X, you need A, B, and C as well, so they can advise them what those additional items may be. And they can also advise the client in obtaining necessary documents. And in the rule, when they talk in terms of necessary documents, they use as examples things such as birth certificates, death certificates, marriage certificates. Those kinds of documents are what the rule is focusing on. The rule also says that the legal technician cannot appear in court in a contested matter or in any other tribunal where the matter is contested. That must be handled by an actual lawyer admitted to practice of law. And also, a legal technician must do their own work. They can't hire somebody else to work underneath them. They're responsible for their own work product, and they must do it directly. As far as the standards of care for a legal technician, they're similar to a lawyer. Legal technicians are held to the same standard of care as Washington lawyers. They're subject to, again, as I mentioned, rules of professional conduct that are to be established for the specific area in which they will be working. And they're subject to the rules of attorney-client privilege and the law of fiduciary responsibility that applies to lawyers at this time. So how did we get to the rule? It starts really back in 2001. In 2001, that's when the Practice of Law Board was created, and that was created under GR 25. And when the Practice of Law Board was created, they essentially had two primary mandates. One was to oversee, maybe the wrong word, but to keep an eye out for unauthorized practice of law. They would deal with complaints. They would evaluate circumstances that were brought to their attention and then work on trying to resolve those problems, trying to prevent the unauthorized practice of law, etc. The other part of their mandate was to provide recommendations to the Supreme Court regarding the provision of legal and law-related services by non-lawyers. And if you think about it, this goes hand in hand with the issues of unauthorized practice of law, because most often you've got non-lawyers performing these services, so it's a question of whether or not some of those services perhaps should be permitted or not. So that was part of the general authorization to the Practice of Law Board under GR 25. The next event was September of 2003. At that time, the Civil Legal Needs Study came out that was issued by the Task Force on Civil Equal Justice Funding. That study highlighted the fact and showed that 87% of low-income households experience civil legal needs every year. And of those that have the civil legal needs, 88% of those had to face those problems without any legal assistance. They found that the key issues through this study were that, one, either they couldn't get someone to help them at all, and that may have been geographic. A lot of these are people in rural areas and the like, but also it was an issue of affordability. So the services that were available were unaffordable to them, even if for some people they might consider them to be of moderate charge. They also found that this was a particular problem for people that are classified as moderate means, which is a bit of a term of art. But moderate means individuals are not eligible for a lot of benefits provided to the people who are truly, in quotes, poor or below certain economic levels. And so the study found that these people weren't able to avail themselves of these services that can be used by the very poor, and they couldn't afford to pay for the services that are otherwise available from people who charge for a living. So as a result of that study, the Practice of Law Board in 2005 decided that they would take a look at this and see if they might be able to develop a rule that would allow non-lawyers to provide some form of legal services to help meet this unmet legal need that was identified by the Civil Legal Needs Study. They first came up with a proposed rule in 2006, and in March of 2006 they presented that rule to the Board of Governors, and that was again during my tenure on the board. When that rule was brought to the board, many of the elements that are in the rule today were in that, but it wasn't as fleshed out as the rule that is currently before the court. When it came to the board evaluated it, heard testimony for and against at the board meeting, and the Board of Governors voted to oppose the rule as drafted. The concerns the board had was that the rule as it was then drafted, they felt didn't really deal with attorney-client privilege issues. They felt that was a serious matter that needed to be addressed. They were also very concerned about the staffing and cost impact it would have on the WSBA, because it appeared that the WSBA might have to shoulder a lot of the economic burden for this new proposed legal technician. They were also concerned when they reviewed the rule and heard the testimony that it wouldn't produce a true lower cost alternative to individuals. So even though the idea is to help people with moderate means, the concern was that people that might qualify as legal technicians wouldn't be charging at a level that moderate means people could still afford. Another concern was that the rule was, my words, nobody else's, a little bit too vanilla. It wasn't focused enough. We didn't know what area of practice it might apply to, and more importantly, if it applied to an area of practice, how would it apply? I mean, how would it really work mechanically? There was, lastly, a concern that there was no market, no insurance market for errors and omissions insurance, and there was a significant concern that there wouldn't be a way for these legal technicians to have economic viability should they end up in a lawsuit for malpractice. So the Board of Governors, although it voted very strongly to oppose that measure. It also voted at that same meeting in March to, in my words, leave the door open to allow the Practice of Law Board to revise the rule and come back to the board if they had a different proposal. So between 2006 and 2008, the Practice of Law Board worked on revising the rule, and they did many different things. One of the things they did do is try and identify specific areas of practice that this might apply to, and they originally looked at 4 different practice areas. They held hearings, they appeared at the ATJ conferences, they tried to solicit input, and they determined through that process and through their own internal procedures to ultimately focus on family law as a possible area of practice for application of the legal technician rule. So with that, they also started to develop a set of regulations that would address the application of the legal technician rule in the context of a family law practice. In January of 2008, the Practice of Law Board submitted its proposed rule to the Supreme Court. It did that under its understanding of GR 25 and the process it was to go through. And at that point, it did not submit as part of the rule the issue of family law being a focus area. It was the general rule. That's the rule that we just talked about. But they then wanted to present the issue, the broader issue, to the board. They continued to do their studies. In February, after the rule had been submitted to the court, the Board of Governors of the WSBA, the president at that time, asked the Supreme Court to not act on the proposal and to give the bar an opportunity to reach out to its membership, to solicit input from them, to try and help educate people about what the rule is and find out what the reaction of its membership was. So they sent out letters to local bar associations, minority and specialty bars, judicial associations. They dedicated an issue of the Bar News to the topic. I'm sure you have this framed somewhere. But the idea was to provide something that had broad dissemination that talked about both sides. I mean, this wasn't an intent to say this is what the Board of Governors thinks and this is what you should do, but rather we want to know from our members, what do you think, and here are the arguments for and against the rule. Let us know what you think. So that process went on, and there were a lot of comments that did come into the board, and the board actually had a meeting, had testimony on the proposed rule in September of 2008. And having gone through that process, the board at that time again voted to oppose the proposed rule. So that has consistently been the position of the WSBA Board of Governors. That is still the position of the WSBA Board of Governors. And as I said earlier, you need to be aware that the rule is in front of the court, has been in front of the court since January of 2008. The Board of Governors and the WSBA has no control over the rule, and it never did because it's a matter for the court to consider and decide. So to the extent we receive comments and input from you, these are comments and input that will be forwarded to the court for its consideration. In 2009 to 2011, this rule was sitting with the court, and originally in 2009 in January, the rule was published for comment, as it is supposed to be under the procedures. The court received quite a few comments, and those are all a matter of, they're available publicly. In November of 2010, the rule was actually placed on the court's agenda. And in November of 2010, the court then decided to table it for consideration until November of 2011. Then in November of 2011, because WSBA knew that this was on their agenda, the WSBA reached out to the court to just inquire what the status was and what was happening. And my understanding is they were told that it had been tabled for a short time frame further. And WSBA, having gone through some revisions to the LPO rules, they suggested that there might be some administrative changes, not substantive changes to the rule, but administrative changes that they felt might make it more efficient, etc. And they asked if they might be able to speak with the court about it. There was a meeting with the court. The court subsequently asked that WSBA provide the administrative comments together with a GR9 cover sheet. That's part of the process for submitting a rule and getting public comment or whatever the court decides to do with that process. And so the WSBA did that. That's the rule, I believe, that is out front, that you can see what those changes are. And the GR9 cover sheet makes it clear that the position of the WSBA has not changed. They are still opposed to the rule, but if the rule is going to be changed, they ask that these administrative revisions be made so that it is more efficient and less expensive to operate. So with that pretty much brings us to today. That's where things are at the moment. The court, we understand, is planning to consider this rule in June. And so that's why we're here. That's why we reached out to you, our membership, to get feedback from you, to give you an opportunity to provide that feedback so it can be passed on to the court. Now, what have the general arguments for and against the rule been throughout this process? I'm just going to kind of give you a summary. I'll read through these because these were the kinds of comments that we were consistently getting. First, arguments in favor of the rule. People of low and moderate means are not able to get legal help now due to the lack of availability and the cost of legal services. Legal technicians will provide trained legal assistance to help meet needs of people of moderate means who are presently either not getting service or are getting services from untrained, unregulated individuals. This has always been a big issue because there are individuals who are not licensed to practice law who are providing legal services. This is the unauthorized practice of law, and it continues. And the thought was, if you at least have a mechanism for training non-lawyers, that will help offset that and provide a better quality of service to people of moderate means. Legal technicians will provide services at lower costs and can be provided by attorneys. Once the system is up and running, then it should be self-supporting through its licensing fees, its own licensing fees. And then the regulations, oversight, etc., will provide protection to the public that does not now exist. Again, getting back to that same concept that we talked about before. In opposition to the rule, there is concern and was concern that the education and training requirements are going to result in a group of individuals providing these services that will not be able to provide them at low enough costs, because they're going to have to incur the cost of getting the training, etc., and paying the annual dues. So the concern is that what they will be charging to people won't be in that cost band that will really help these people of low and moderate means. There is also that these people with that kind of training and experience are less likely to decide to go and work in those areas, those geographic areas that really have the greater need, the rural area, the low population areas. There was a concern, significant concern early on that the program was going to cost more than it was going to be able to pay for, especially at the front end. And considering the pressures on the WSBA already, that was an expense that the WSBA shouldn't be required to pay. And you know, the dynamics of how much this would cost has changed over time, and that may be something that people will want to talk to. I guess I would just note that when it was originally prepared in 2008, at that time there was an estimate that it would cost $200,000 approximately to get the program started and running. There was significant debate about whether that was a hard number or whether it might cost dramatically more than that. It was unclear. With the changes to the administrative structure that have been proposed and with some other changes in dynamic, my understanding is that the current estimate is the initial cost would be about $100,000. I just throw that out there because that's the information that we have at this point. The other concerns are that the types of services that legal technicians will handle are going to be so limited that a lot of the needs of the low and moderate means people still won't be addressed by the legal technicians. There is still some concern that there is no available errors and omissions coverage. And so how are we going to find financial capability if there is an act of malfeasance? An undercurrent through all this as well has been that by creating legal technicians, some people feel that you're now telling people of low and moderate means you're not entitled to the same kind and quality of legal service as a person who has more and can hire a real lawyer. They now have to use legal technicians. And then the last comment that has been consistent throughout the process is that really what people should be focusing on, the court and the bar should be focusing on, is expanding other ways to provide these services to the low and moderate means individuals through pro bono services, statewide moderate means programs. Those kinds of things should be the focus, not the legal technician rule. So that is an overview of the rule, of how the rule got where it got, where we are, and what people have been saying are the pros and the cons.
Great, Doug. Thank you very much. So at this point, and my apologies, I forgot to introduce Michelle Radosevich, who is standing in for Steve Crossland today, who's missing in action on an airplane someplace. Thank you, Michelle. At this point, first of all, I want to remind the folks who are participating by the webcast, this is the time that you can start typing away and sending your information in. There are 3 people in the booth in the back who are ready and willing and able to take your comments and bring them forward. We're going to try and intersperse those with the comments from folks in the room today. I've talked to a number of you on the phone or by email, so I know there's lots of people with opinions here who are ready to make those comments in person. So I'm just going to, by the luck of the draw, start with my friend Ishmael, who called yesterday. And we're going to move this way counterclockwise from the room. So Ishmael, I have an official timekeeper here with an Olympic clock, and he's going to try and keep us on track to 3 minutes or so. So welcome, and everybody, if you come to the podium, please state your name, where you're from, if you feel comfortable doing that, and just so that we have a complete record when the tape is made.
Great, thank you. Good afternoon. My name is Ishmael Dickens, and I'm here representing the Access to Justice Board. Thank you for providing me with an opportunity to state the ATJ's support for the proposed new Admission to Practice Rule 28. The ATJ is on record, see the August 15, 2008 memorandum to the Supreme Court and to the WSBA Board of Governors, supporting the concept of a rule that would open up the availability of limited legal services to those populations who cannot afford lawyers and who therefore have to represent themselves. In that memo, the ATJ clearly indicated that its support of the rule was made on the basis that such a rule would promote access to justice. Indeed, the ATJ's mission recognizes that access to the civil justice system is a fundamental right, and the ATJ board works to achieve equal access for those facing economic and other significant barriers. The ATJ board takes its responsibilities very seriously and relies on input from members of the Alliance for Equal Justice as well as legal needs studies as it determines its priorities. One such study, the Civil Legal Needs Study of 2003, provides an unprecedented look at the civil legal needs of low-income households in Washington. While the study is now 10 years old, there can be little doubt that the unmet legal needs of people living in poverty continues to grow. As Mr. Lawrence commented earlier, this 2003 study determined that low-income households with legal problems face 88% of these without the help of an attorney. The proposed rule would be an invaluable resource for people living in poverty. They are literally crying out for help, and the legal profession has a responsibility to respond to these pleas. The availability of limited licensed practitioners would simply provide one more tool in the toolkit, allowing all of us who care about access to justice to provide as many resources as possible so that everyone in the state who needs it is provided with this access. The proposed rule would not detract from any other practice already in existence. Attorneys will continue to be hired to provide their professional services on a wide range of issues. There will be the same demand for pro bono assistance. Indeed, the number of attorneys providing pro bono assistance is stagnant, and there's no reason to believe that pro bono services will increase anytime soon. Existing programs serving the needs of low and moderate income households, whether provided through staff legal services or through innovative programs like the Bar's Moderate Means Program, will continue to do their best to serve the needs of the clients who walk through their doors. Though decreased funding will probably result in more and more of these potential clients being guided towards self-help resources or simply being turned away. The ATJ's plain language forums will always be in demand as soon as they are available, and court facilitators will continue to play an important role helping self-represented litigants. Add to all of these the availability of limited licensed practitioners, and we get closer to meeting our obligation as lawyers of providing justice. It seems to me that lawyers who care about access to justice are constantly asking themselves, what more can we do? Indeed, in the past year, the WSBA established the Civil Legal Needs Work Group, whose charter requires them to look at additional ways to address issues related to representation of low-income clients, including, but not limited to, disseminating legal information, providing legal advice, and/or undertaking representation of eligible clients currently not provided by existing legal aid providers. I think we all recognize that when people living in poverty are not provided with the necessary tools to navigate the justice system, then they are more likely to lose their jobs, end up being homeless, and/or face disruption within their families. Our current resources are stretched to the limits and are becoming overwhelmed as budget cuts impact legal aid providers' ability to hire staff and provide much-needed services. Justice Ireland is here with me today in support of the proposed rule. On behalf of the Access to Justice Board, I ask the WSBA Board of Governors to reconsider its position regarding the proposed rule and to join with the ATJ in supporting proposed APR 28. I urge the Supreme Court to adopt APR 28 as another important step towards the provision of access to justice for those most in need of that assistance. Thank you.
Thank you so much. I was going to ask if Justice Ireland had anything to say, or you're just nodding in agreement with Ishmael. All right.
Good afternoon. My name is Brad Lancaster. I practice in a solo practice in Shoreline, Washington. I practice right in the middle of Shoreline, the part of Shoreline that has no shoreline. The expensive parts of Shoreline, you can see the water and your houses are valuable and you must have a better job. My part of Shoreline, people don't have such good jobs. They work two jobs, and when one of them loses their job, they are fresh out of luck. Their mortgages are in trouble, and their households are in trouble. Their marriages fall apart. They need help with their landlords, and they can't get it. So we lawyers, we're a monopoly. We control access to the legal system, and the legal system is the recourse we offer people. If people can't get access to it, then we have denied them justice. As a monopoly, if we value our well-being, we will fix that. People need to be able to get professional help with their legal problems. About 70% of people in King County don't get an attorney when they get divorced, the most important legal transaction in most of their lives. That's a terrible outcome. So we have a duty to all citizens, in my view, to make sure that they can get at least some well-educated help. They can't afford many attorneys. I wore these clothes today. I know I'm supposed to wear a suit and a tie. I wore these today because these are the clothes that make my clients comfortable. And I wore them today to let you know that there's a cultural difference between people like us who have vast privileges, vast education, vast opportunities, and these other people in our culture who are the vast majority, who have fewer opportunities, less education, and less resources. Ethically, we are all together. Us smart ones, us educated ones, us dumb ones, us disabled ones. We are together. And it's the job of those who have privilege and access and intelligence to provide some help and some hands up to the people without it. And we're failing in that. Us attorney monopolists are failing to do that in Washington State. I think this rule does something about that. Its particulars I'm willing to talk about, but we need to take much more seriously our task of providing legal services to everyone in Washington. So I hope the Board of Governors will change its position, and I encourage the Supreme Court to spank us if they don't. We need this legal technician rule. Thank you.
Thank you very much, sir. Ruth? We're going counterclockwise. I want to catch everybody on the right side of the room first. And if you want to go maybe sit on that side of the room, anybody who wants to speak, get in line, then I'll know you're ready to go.
Thank you. My name is Ruth Edlund, and I am here on behalf of the Family Law Section of the State Bar. I'm the immediate past chair of the Family Law Section. I'm a partner in the law firm of Wechsler Becker, LLP. As an initial comment, I would like to raise my objection to the change of the phrase legal tech to limited license practitioner, or LLP. One of the difficulties that I see is that I note in your rule H4, an LLP was forbidden to represent or advertise in connection with the provision of services, other titles or credentials that could cause a client to believe that the limited license practitioner possesses professional skills beyond those authorized by the license held by the limited license practitioner. So either you would then need to forbid them from using the designation of LLP, which also stands for Limited Liability Partnership, which many attorneys practice in the form of, or if you decide that's okay, you have created a perception potentially in the public's minds that someone who is a member of a firm, for example, our firm Wechsler Becker LLP, then appears to be providing services as limited license practitioners, and you have therefore diluted our business advertising. To give you an idea of where my personal perspective is coming from on this rule, and to as I articulate the Family Law Section's strong opposition to this rule, I have been doing pro bono family law since 1984. I received an award from the state of New York for doing so. I ran a pro bono program, the King County Bar Association's Family Law Mentor Program, for 5 years. I am very aware of the problems of the poor, but this rule is, in my view, a feel-good rule that would make us feel that we're doing something good, but all we're providing is access to injustice, because the class of individuals described is not going to have the competency to actually do for the poor what needs to be done. Just because you're poor doesn't mean your legal problems are simple. In addition, I have repeatedly made inquiries about what kind of business model is postulated for individuals who would be obtaining the limited license practitioner LLP designation, and what would they have to charge in order to make a profit. What is their assumed business model? What could they charge? And I have never been presented with any indication that anyone's ever actually done that work and been able to verify that if this class of individuals was created, that they would actually be able to stay in business. My understanding by analogy from LPOs is that the number of limited practice officers in the real estate area and it has dropped substantially in the last year, perhaps because of economic concerns. So I think it's the easy way out to say, okay, we'll create a new rule, now we're doing something. In my view, this is not going to help, and I ask the board to not to change its position, but to stay the course and look beyond the simple and superficial answer. Thank you.
Thank you, Ruth.
My name is JerryStimmell. I'm a sole practitioner in Kirkland. I oppose the rule in part because of the reasons set forth by the preceding speaker. and in part because of the principle established in that great precedent known as All the President's Men, the book by Woodward and Bernstein. And in the movie version of that book, the informant is supposed to have said, always follow the money. And in this case, it is assumed, that is, the rule assumes, that somehow the money will be less expensive, or the service will be less expensive for the clients who need it. And I don't think that's possible. I believe that is a fanciful expression in this rule, and you cannot have carefully sought after or carefully given service that much cheaper than a lawyer can give it. Just because somebody doesn't have to go to law school doesn't mean that the care to be given to the client doesn't have to be well thought through. It can't be that cheap. Now, the State Bar Act requires me to be a member of this organization and to pay dues to it. But I don't think the State Bar Act requires me to subsidize non-lawyers. Maybe the Supreme Court will say that it does, but I oppose wedging this kind of service into the kind of service that I'm supposed to subsidize with my dues in the State Bar Act. Again, always follow the money. This is fodder for the dues rollback petition that I would normally not support. But the rollback petition seems to be gathering some merit in my view if I have to subsidize service that I believe is misguided in this rule. The objections of the board that Mr. Lawrence set out, having been previously voiced to the Supreme Court, are not solved in this rule. The rule makes a very pale effort in setting up a framework for a trust account and privilege. But I think that that pale framework does not do the job, and the reasons for opposing the rule that the board has previously expressed should be persisted in, and the board should oppose the rule still. Thank you.
Thank you, Jerry. I'm going to ask you to hold on for just 1 second. I'm going to throw it to the folks in the back of the room. Are there any burning comments or questions? Or
I have several.
All right. Why don't you take it for a couple of minutes?
So this is from Pete Karadimas. Over the last 8 years, I've attended the first vote of the Board of Governors as a representative of the Family Law Section, and I participated in the second vote as a governor on the Board of Governors. Those two votes were substantially in the majority against the rule. Why is it back, and why is it different? In family law, we look for a substantial change of circumstance to review a previous order. What circumstances have changed to justify a review of this rule? In a second comment, Pete writes in, can you answer a question I've asked for 8 years? How much will legal technicians charge to meet their needs for overhead and salary? What class of people will be helped? The very poor cannot pay very much and therefore will not be helped. There is no restriction on available finances to access legal technicians, so the wealthy could go there with an ability to pay. So why would legal technicians help those who cannot pay?
Well, Pete Karadimas has always been famous for his rhetorical questions, so I'll try to answer the first one, which is why is this rule back now when it's been laying dormant for the last 3 years? Doug, in his preliminary comments, went through the history of how it got to the court, why it's been at the court for the last 3 years, and I, sort of in my own vernacular of referring to this, it's been parked in a drawer really for the last 3 years while the court has continued to consider it. And it's back now for a vote because the court has decided that that's what it's going to do. And the court has a specific process for doing that. They have a calendar at their en banc meetings, which happens, I believe, once a month. It's regularly calendared. And it was on for vote, I believe, in November, based on some discussions that members of the WSBA had with the court at that time. They agreed quite kindly to push this matter over for a vote until June of this year. So in answer to that specific question, Pete, that's why the rule is in the present state that it is now. It's just the passage of time and the fact that this rule belongs to the court owns it, and the court will put it on its calendar, and has put it on its calendar for a vote at this time. As to the second question about who's going to be served by this and what folks are going to be charging and how much it's going to cost for these services, I guess that's an answer that the marketplace will have for this. There's no set fees. Pete probably charges less or more than I do for certain things, so I think it will all be determined by the marketplace. Do you have anything to add to that, Doug?
No, I don't.
Just hang on just one second. Anything else from the back?
I have lots more.
Why don't we take two more and then we'll get back to the live comments.
Sounds good. So this is from Lisa Seifert. I'm on the call from the Washington chapter of American Immigration Lawyers Association. We have been consistently interested in the topic of licensure for non-lawyers in the immigration area. We continue to strenuously oppose any kind of licensing or permission for non-lawyers to work in the immigration area. At the federal level, there is a process for approval for accredited representatives of nonprofit organizations to be approved and supervised by the Executive Office for Immigration Review in Virginia. I am sure the bar is aware of the work done in the state legislature last year when previous immigration practitioner register was abolished, and in its place, additional consumer protections were implemented. We think this is a tremendous step in the right direction by the state of Washington. I will look for statute references. I will be listening live today and will make other comments as they come up. We already have another comment from her, so I'm going to read that through for the first time. Every year, even every month, immigration lawyers see the harm done to immigrant consumers for non-lawyer services. Immigrants already want to trust notaries who heavily advertise in foreign languages, that they can solve the problems for work permits, visas, or even deportation defense. The results are disastrous. Clients are damaged irreparably. Our area of law is one which is difficult to learn. The consequences of misadvising are usually permanent. It is difficult enough to police the malpractice of attorneys who do not know what they are doing in this area. The state bar should help prosecute, not promote, unlicensed people who want to do immigration law. We encourage the bar to help fund pro bono organizations such as the Northwest Immigrant Rights Project to provide legal services to people who need pro bono assistance. As far as training, the federal level provides a program for accredited representatives who must work for a pro bono organization that is accredited by the Department of Justice. AILA supports non-lawyers to work in this area who are approved accredited representatives. We have dire concern that any state agency, this Bar Association, or the Washington Supreme Court could provide any substitute program or could supervise any approved persons. We will submit other written comments.
You have one more short one, and then we're going to go back to folks who are here in the room.
Yep, most of them are longer, so I'm going to defer for the time being.
Okay, well, why don't you sort through those, and we'll take up back with live comments, please.
Thank you. Good afternoon. My name is Peggy Sanders. I am here on behalf of the Washington chapter of the National Academy of Elder Law Attorneys. NALA is a nonprofit association of attorneys who devote a significant part of their practices to work with elder clients and their families. The Washington chapter commented to the Supreme Court at length in a letter dated April 27, 2009, and our position has not changed. And we still believe that it's not good public policy or even possible to sanction the practice of law in any areas, but particularly in elder law. I'm also here as a solo practitioner who also practices in Shoreline. And I'm new to the discussion. I'm new to the practice of elder law. Unlike a lot of my colleagues, I've been doing this for a relatively short amount of time, and I already know there is no such thing as a simple will. There's no such thing as a simple power of attorney. Not if you're going to provide high-quality advice and counsel to elder law clients. I also, because I'm new at this, I went back and looked at some of the documentation that you referred to in your introduction, and I got page 47 of the civil legal needs study, and it talks about why don't people get help. So I looked at the reasons, and only 22% was cost. 73% was lack of knowledge, lack of education, not knowing what their rights would be, and so forth. So, for example, thought nothing could be done. That was 27.9%. Didn't know who could help, 24.1%. What we need is to get information to people about what their rights are and how they can take advantage of legal assistance. I don't think that the proposed rule does anything to address that part of why people don't get the legal services they need. And the last thing I'll say is in response to one thing that you said in your introduction, and that is, there's a lot of people that are practicing law without a license now, and what makes us believe that they won't do the same thing without getting the license as a technical practitioner. So thank you very much for allowing me to talk today.
Thank you, Peggy. My son lives in Shoreline. I'm very glad to know that there's so many thoughtful people that are from Shoreline that have come down here today. Thank you very much. This is for members to make their comments, so we're not going to be entertaining questions from governors right now. Actually, Bill, I'm going to ask that, since you're on the Board of Governors, I want to make sure that everybody who is here that is not a member of our organization has a chance. I want to make sure that they have a chance to speak first. I
asked to read in a comment that I solicited and got.
I'm sorry, I need you to go to the microphone.
Under those circumstances, I will allow you to move forward if you identify the person who made the comment.
Well, as Nancy's pointed out, my name is Bill Vial. I'm Governor District 8. I actually tried to solicit and receive some input from constituents and happen to get one, which I will read into the record today.
Thank you.
These are the comments of Mark Schindler. APR 12 and the Limited Practice Officer Program is held up as a model for this proposed program. As you know, I'm a past chair of the Limited Practice Board and have been involved with the rule since its inception. In practice, the LPB program has had few problems related to competence. This does not mean that it has been a success. The cost has risen, the scope of services declined, and we have enabled the competitors of lawyers to drive lawyers from an important area of the law. Unresolved claims in the escrow area lie largely with independent escrow companies, a very small part of the industry. Title companies dominate the escrow world and are mostly able to cover their liabilities. The areas of licensing contemplated by the proposed rule do not have the equivalent of title and insurance companies to pay for their mistakes. The LPB experience is therefore not a reliable indicator of how a similar structure would work in divorce or in other areas. The profession is under siege. State agencies are licensing people to negotiate in several areas. Non-lawyers are increasingly practicing law as consultants, brokers, and others. The bar is considering relaxing admission rule to allow foreign lawyers to practice in Washington and compete here. Non-lawyers want equity positions in law firms. At every turn, we see the message that commodity work done by others would be cheaper and better for our clients. I am not convinced. The LPB rule took a leverage opportunity for attorneys and handed it to non-lawyers who don't do the job as well. Licensing non-lawyers to act independent of lawyers will make it harder for lawyers to compete or to bring along new lawyers. The non-lawyers will not be cheaper. The public will conclude again that lawyers are not needed. As with real estate, some will be harmed with no remedy.
Bill, thank you for channeling my friend Mark Schindler. Thank you. All right, I'm going to take this gentleman, and then I'm going to go back to the booth, so if you want to cue some up, thank you.
Hi, my name is Forrest Carlson, and I'm a sole proprietor here in Seattle. I graduated in 2008 and started practicing in October that year when I was finally sworn in. I think that I don't want to assume anything about the age of anyone in this room, but I'm going to. I think I may be the youngest person here. And so I'm going to speak on behalf of young lawyers who are not here today. I'm guessing because they're probably very busy, maybe working 2 jobs, maybe not law-related jobs that they wish that they had. My understanding is that there are 50,000 new lawyers licensed every year in the United States. I think it would be fair to take the temperature of the young lawyers and the new lawyers who are not young in the state of Washington and ask, what could we be doing with these people who they already have a law license and they can't find work? Because these legal needs, well, they're not being met, but then we have lawyers who need to do the work. There's a huge population that could be mobilized for that purpose. This rule, I think, would cut into the work that would otherwise be available for young lawyers. And I'm a sole proprietor, not necessarily by choice. I think it's something that grew on me after a couple of years working for someone else, but in part out of necessity, because it could have been either I leave the legal profession or I go out on my own. And I think that there are a lot of people who are really stuck with that choice with less leeway than I had when I made that decision. It's extremely tough. It's very expensive. I'm going to speak openly. I came out of law school with $150,000 of debt, and I have to pay that back. If somebody comes to me and wants legal service at a lower rate than I have to charge in order to pay the bills, I simply can't offer it. But I know that there are a lot of people who are my colleagues who graduated around the same time I did, who are licensed, that can't find work and would love the opportunity to do work, even if it's in a position created for the purpose of providing pro bono service or moderate means. But when you have $150,000 of law school debt, I think I was just at a CLE earlier today where that was a financial advice CLE for young lawyers, actually, coincidentally. The average debt is $120,000 for students coming out of law school. You just can't do work on a budget. You can't really afford to do pro bono work when you can barely afford to pay your business expenses and put food on the table at the same time. So I think that the better solution would be to move towards something like Civil Gideon, toward more moderate means of attorney work, and we could fund that by increasing our dues rather than decreasing them. But I think the money's there. It's a terrible thing when the best and the brightest in the legal community in Washington State turn to the people who have unmet legal needs and say, you don't get a lawyer, you get a legal technician. So I'm opposed to the rule for every reason that has been given in opposition to it so far, but also for the reasons I stated on behalf of young lawyers. Thank you.
Thank you very much, Forrest. All right, if anybody in the room wants to queue up over here, I'm going to take a few comments from the back of the room and from folks on the web.
I have several comments on educational requirements. I'll read all those together. This is from Carrie Kay. I'm licensed both as an attorney and as a real estate agent. As such, I deal frequently with both other real estate agents and limited practice officers, escrows. As a general rule, they don't have even a basic understanding of the legal issues in the area they operate in daily. I don't see limited education and training changing that. This is from Pierre. Why do non-lawyers with an associate's diploma qualify? Frankly, I don't think they have the necessary training or educational qualifications to really qualify as one who has obtained a bachelor's degree from a university. Stephanie Delaney says, the education requirements are stringent. I've been a paralegal educator and helped write the rule. We were very concerned with high educational standards for the legal technicians. Judith K. adds, they can become limited practitioners with an associate's degree. Could be obtained in a high school and running start. All attorneys have a minimum 7 years beyond high school. I also hear nothing that would limit this service to people with an adjusted gross income of under $50,000 or some other number, suggesting this is not really aimed at access. Carrie Kay then follows up, I would question what training is really given in a paralegal legal assistance course. Finally, from Brenda, bottom line is low-income individuals are turning to unlicensed individuals to meet their legal needs. I don't know how many I've talked to who have lost custody of children, etc., from relying on someone they found on the internet to help them with a custody issue for a low cost. We need the regulation piece to protect the consumer. The education and experience requirement, along with the testing component, will help to ensure qualified individuals are providing the service.
Thank you. All right, I'm looking around the room. Nobody else in this room has anything to say on this? Jean Cotton, I know you do.
I'm waiting.
You're waiting? Okay, well, you may have. Yes, that's fine.
Yep. I do have additional comments as
well.
well.
We're going to have this gentleman come up, and then I'll go back to you.
Hi, my name is Walt Williams, and I'm an attorney at the Ingle Law Group. And while I'm not a young man, I am a young attorney, like Mr. Carlson. We went to law school together. I was a paralegal for 17 years before I decided to become a lawyer. And in fact, I worked upstairs here at Peterson Young Putra, and I was very good at what I did, very good, and very confident in what I did. But after law school, I learned that there was a lot more to this job than just pushing the forms. And as an attorney, I've seen work from paralegal services that had made mistakes that I might have made as a paralegal, because the analysis in some of these cases at the very beginning could be as simple as venue and jurisdiction. Very simple for an attorney, but maybe not for a paralegal or one of these services. I saw cases that were filed in Lincoln County because that seemed to be the easy thing to do. But some of these people ended up with their cases in Lincoln County, and they needed to be here in King County, but they didn't know how to get them back over here to King County, and it was too late. It was a mistake that was made by one of these services. Same thing with joining a petition. Knowing what the ramifications are of joining in a petition and what that can mean further down the road. Some of these services, they don't know what that means, and it takes an attorney, that type of analysis, to figure that out. And for those reasons, that's why I would oppose the rule. Thank you.
Thank you very much. Back to the booth.
There's been a discussion online about the hourly fees legal technicians might charge and why the rule does not restrict the amount of the hourly fee. One online attendee wrote, this rule will extend the same lack of quality professional work to other areas. Kristen followed up with, it seems to me that this rule is just creating a whole new bureaucracy. Although a legal technician would not have to pay for law school, they will still have substantial overhead for which they will have to charge. It seems like they will have a bar type exam that they will have to pay for, continuing education credits which they will have to pay for, a yearly licensing fee that they will also be paying for, etc., etc. The expenses are not that different from what we all have as lawyers. So why on earth do we suppose that the services will be any less expensive? William S. then says, bad idea, then, now and in the future. Those of limited means will be preyed upon by non-lawyers. They didn't let hygienists practice dentistry. Why create legal techs? Ann V. adds, those of limited means are preyed upon by non-lawyers right now, all the time. Check Craigslist. Vicky P. adds, I also have had to clean up after our current limited license practitioners. This is not good. Just a question. Are we a social service agency now? And is this proposal helping anyone? William S. Why doesn't the Bar Association and the law crack down on those people preying on them by practicing law without licensure? Kirsten R. says, creating a new field of legal technician is not going to stop unscrupulous people from preying on the poor and uneducated regarding legal issues. That's all I have at the time.
Well, was a common thread in there, but one of the comments that I'll respond to is the Bar Association is not. We don't have the prosecutorial ability to go after people who practice law without a license. That's something that is in the hands of the various prosecutors across the state of Washington, and budgets are tight and they prioritize the work that they do, and unfortunately the unauthorized practice of law doesn't typically make it on too many prosecutors' radar screens. So I think that probably accounts for the fact that that particular criminal activity, to the extent it is, doesn't get much attention. All right, I'm going to ask the folks in the back of the room, do you have some more comments? Because the only other person I know is Jean Cotton, but I'm going to give everybody one last chance to, well, just hang on a second. I'm not forgetting about you, Mark, but the Board of Governors are going last because we are making comments. We're making sure that everybody here has a chance to speak first. Yes, ma'am, come on up. I'm glad you're here, and I'm glad you are.
Hi, I'm Grace Wong. I'm with the Washington State Coalition Against Domestic Violence. And for those of you who don't know, we are a membership organization of 75 domestic violence shelters and advocacy programs across the state. And we actually have mixed, as an attorney, I have mixed feelings about this, having practiced very complicated area of law. As Lisa Seifert indicated earlier, immigration law is where I used to practice, and I really saw the consequences of individuals who got bad advice, both from attorneys and from non-lawyers. But I do want to highlight the model that Lisa mentioned, which is that one of the accredited representative structure within the immigration law context, where there is a requirement of supervision by attorneys, or at least a thorough training program put together by the Department of Justice. The individuals that our programs see have complicated family law cases. They cross state lines to get to get safe. They actually work with attorneys that don't know a lot about working with domestic violence and really screw up their safety for long, extended periods of time. And so attorneys do not have the monopoly on providing representation that is adequate for domestic violence survivors. And so, I think that I would like to see a model that utilizes our existing social service structure. There are areas separate from domestic violence, such as housing, homelessness. There's other service providers out there where people are not interested in making a profit in this, but want to make sure that individuals get access to the help that they need, and a much more thought out and structured rule around how people might get training and supervision would be very helpful for the individuals that access our programs and need access to legal services. Thank you.
Thank you, Grace. All right, Julie, back in the back.
So this is from EEOC Administrative Judge Zulema, and forgive me, Your Honor, I'm going to mispronounce your name, I'm afraid, Hinojas Fall. By federal statute, plaintiffs are permitted to be represented by anyone, union reps, neighbors, family members, etc. The system is a disaster. In the 10-plus years I've been adjudicating employment discrimination cases, I have seen a great amount of self-dealing by non-attorneys and representatives, non-attorneys / representatives. There is no accountability. The WSBA's disciplinary system and the ethics rules protect individuals. Paralegals are supervised by attorneys who are under the rules of professional responsibility, are held accountable for the paralegal supervision and practice. Plaintiffs damaged by legal text will have no recourse. The AG's office will not prosecute this case as it does not currently prosecute unlicensed, disbarred attorneys. If we really want to help those who cannot afford attorneys, we should look to the model already in place in the EPA, for example, where pollution credits can be bought. In our case, attorneys could be granted credit on license fees in exchange for legal work at reduced rates.
All right.
I have a few more that we're gathering.
Okay, well, hang on just one second. You feel like you're ready to go here, Jean? Okay. I think Jean wants to make the concluding statements here. So, all right. In the booth.
So I'm reading through these for the first time. From Gary, almost every section of every family law form, which by the way seems to be a favorite justification for this target of this proposed rule, has an option for, quote, other, close quote. If the tech can't practice law, how will he or she even begin to advise a client concerning the myriad of specific scenarios that fall under that discretionary option? And then Ruth Spalter follows up, it occurs to me that attorneys are in the practice of law. That means we practice it, not just read it, study it, write it, etc. The practice of law involves going to court, and there is a lot to know about courts that can only be learned by practicing there. That knowledge is within the attorney and informs the advice they give their clients and the way they fill out the forms, etc. There is no possible way to educate limited licensed practitioners to that level, which in my opinion is necessary to give access to legal justice.
Well, I'll just make one comment, and this is my own personal opinion. There are a lot of people that are filling out that forms who have absolutely no legal training at this point. So, and one of the projects that the ATJ board has been involved in, that the WSBA just made a financial contribution to, is translating at least the family law forms. That's where we're starting it from legalese into more understandable plain English, which will have a twofold benefit. One is to make the forms easier and more understandable to folks who are representing themselves in this system, but it will also make it easier for the lawyers who have to utilize those forms in their everyday practice. So there's some question that came up that I was going to ask Doug to take, but now it's gone out of my brain, so I apologize.
I'm just waiting.
I can't remember what it was. So maybe it was about the educational requirements. I don't know. Well, it'll come back to me. Is there another comment from the back?
Additional comments from Pete Caradimas. So dealing with issue of child placement is very complicated and depends a lot on your presentation in court. Rule does not allow legal technician to go to court. Not helpful at all for the poor. And then we all believe in access to justice, but we need to find the answer of how it is provided. Creating this new level of practice is not the answer. 8 years of consideration by many intelligent people and groups have led to a rejection of this rule, and the Supreme Court should reject it also. And let's see. I'm not buying some of the cost arguments, because increased supply will tend to reduce costs. The biggest issue I've heard is the lack of insurance. This is a huge problem.
Participating by web, it looks as though we are going to be able to wrap this up a little early. We had 2 to 4 allocated, actually 2 to 5 in case we had throngs of people standing out in the hallway. But it appears as though we're going to be able to wrap this up in the next 5 or 10 minutes. So if you're participating on the web, please make sure you get your comments in writing to the folks that can make those available to us. And if there's anyone else that wants to speak at this time, I'm going to ask them to queue up at the podium so we can get everybody in.
Good afternoon. My name is Elizabeth Edwards. Forgive my state of dishabille. I'm one of those young attorneys who's looking for legal work right now. I have to admit that I read over this briefly beforehand, but I'm trying to understand where the impetus for this is coming from, and I'm wondering who wrote this model legislation, this model rule, and whether or not other states have done it, and has anyone looked at the success of other states implementing such a limited license rule.
You have that specific question. I think Doug can answer that for you.
Well, there is nothing that matches this particular rule. There are a couple of states that have document preparer rules, which is different. I mean, this is a more expansive. I am not aware of any other state that has a legal technician rule such as this. So it's a little bit of cutting ground, as it were. As far as who prepared it, the Practice of Law Board prepared it over the course of several years from their own internal discussions and reaching out to the community and having hearings and getting input from other people. As you can tell from a lot of the dialogue that we're hearing today, there's more than one way to look at an issue and how it may be addressed. But back to your specific question, is there another rule like this one? No.
Thank you.
You're welcome.
Thank you. My name is Leslie Savina. I'm the statewide advocacy coordinator for family law at the Northwest Justice Project. However, I don't speak today for the Northwest Justice Project. I speak today as a 30-year member of the WSBA Family Law Section, and probably the only person who's going to come here today and say, well, this rule really does not go far enough. You know, why hold back? I think if people really read the rule very carefully, it's a beautifully crafted rule. It's really well thought out, and many of the issues that are raised by people who have objections to the rule are actually addressed in the rule. If you read it, you know, the answer is there. Somebody earlier said follow the money, and that seems to be a very recurring theme in here. It's all about the money. Show me the money. Show me the client. I'm a lawyer who doesn't have enough work. How's this business model going to work for these legal techs or limited liability practitioners? You know what? When you pass the bar, there's no guarantee that you got work. If you're a member of the bar or if you're a legal tech, there's no guarantee. It may work, it may not. Who knows? I think it's really well regulated. It's supervised by attorneys. I think everybody here agrees. We certainly see it in our work in legal services frequently. Bad advice from, you know, we be lawyers or lawyers be us or whatever. You know, I'll fill out your forms for you. It's horrible, it's horrendous, and it's a really big problem. There's really, as Nancy said, there's no way to prosecute that until you get the prosecutor to bring charges. And boy, I've tried that a time or two, and it's pretty darn, one case we've been successful with. It's very difficult, so people will be regulated. They'll have oversight. Will it give people second-rate legal services? I certainly hope not. I'm here to say, and I know the Supreme Court may be watching this, but I did, the statute of limitations is run, I did unauthorized practice of law in the 70s. Back in the day, it was a feminist organization called the Women's Divorce Co-op in the University of Washington. We were referred cases by the Bar Association because we were the only game in town. We were the only game in town to help low-income women do their own divorces. And it was absolutely unauthorized practice of law, and we did a bang-up job, and we helped people. Right now, there are people in Washington State who may not have a contested divorce, but they just need to get the job done. They're monolingual Spanish speakers. There is no place for them to go to have somebody help them do those forms, help them fill out the forms. A legal technician working with an attorney or under the supervision of an attorney could do a fine job and really help people there. And if you want to work for the same rate as a legal technician might work, there's plenty of work out there. And I appreciate that it's very expensive. I paid my loans back. I'm done, thankfully, because now I'm paying tuition for kids. But it's hard, it's expensive. But I think working with a lawyer, working with supervision, being well educated, let's not be arrogant. 3 years of law school doesn't make us really know everything, and that's why exactly we call it practicing law. You can practice being a legal technician as well. Thank you.
Thank you, Leslie.
Good afternoon. I'm Rita Bender. I practice here in Seattle. My practice primarily consists of family law issues and legal ethics issues. I was a member of the Practice of Law Board earlier on. I haven't been involved with it directly in several years. There are a few comments that I do want to make, though. When the board, the Practice of Law Board, first started talking about the possibility of something which came to be called the Legal Technicians Rule, what we were talking about was the fact that there is a large group of people who are not the very poorest, who could not come up with 2 nickels to rub together for legal services, and people who can afford the cost of lawyers, even fairly modestly priced lawyers. There's that whole category of people that fit in between and who don't know how to turn, don't know who to turn to, often turn to people with absolutely no training who hold themselves out, as been said today, on the internet and do disastrous work for the people who they claim to be advising. To have people who are trained to give some limited services, and again, if you read the rule carefully, you'll see that they are limited services. To have those people trained to be able to provide some advice and some assistance so that folks who can't afford lawyers and are not likely to go to lawyers can get some help in finding their way through the process makes sense. It also is true that one of the reasons that those folks who are out there without any training, who are preying upon people who need legal assistance, are not prosecuted is because it is very difficult to prosecute them. And one of the things that we found on the Practice of Law Board when we made referrals to various prosecutors was it was extremely hard, not just because of their time constraints, but because of proof issues. So having a legal practice rule, having limited practitioners and requirements for training and licensure creates a bright line. Anyone who is providing services and hasn't done those things and hasn't been licensed is clearly violating the law. It makes those prosecutions an awful lot easier and more likely to happen. We can help shut down some of the bad things that are going on now. As to insurance, you know, insurance providers tend to move into markets. And if there is a limited practice rule, and if there are people who want to be licensed, and one of the things they have to do is get insurance to be licensed, there's a pretty good chance that there is an insurer out there who is going to offer to provide the insurance. If it doesn't happen, well, then as somebody else said, the rule can be put out there, it can be tried. If they don't come, they don't come. Just a couple of other comments, and I guess what I want to say is I've always been personally, and many of you I know, have always felt strongly that people who cannot afford our services should still have lawyers. And no matter how much pro bono work any of our law firms do, we're a lot less than a drop in the bucket. We cannot do it on our own. And we have seen in recent years the very limited federal programs, legal services programs that exist being cut back further and further and further. And so the staffing that once was there and that was never adequate is far less adequate now. This is not a solution in itself. It is one piece of an effort that we all have to be involved in. I agree with the young lawyer who said we should tax ourselves. Those of us who are paying bar dues ought to tax ourselves to provide more legal services. Great idea. I'll sign up, will you? That won't solve the problem either. It will be one small part of a problem solving. Thank you.
Thank you very much, Rita. Back to the booth.
So I do have quite a number. From Lisa Seifert, imagine trying to ensure errors for these non-experts. Not a good bet. Mark M. states, I would expect that distinguishing law practice from legal technician service is going to be impossible, practically, in any actual pursuit of a claim of unauthorized practice of law. If there ought to be such a thing as, quote, authorized practice of law, close quote, it will become virtually unenforceable, even if prosecuting authorities have unlimited resources. So Vicky P. adds, here to Gary G's earlier, who let me remind you, commented earlier that about the other aspects in family law forms. Vicky says, it's the same with wills and probate. There are complications. There's no simple will or probate. The only result is a lack of options within a will or probate. Further, who said all attorneys charge more than the charge a tech would charge? An attorney may even charge less. I'm sure I do given the original proposal. It is not difficult to comment when the areas of legal practice are unidentified. Online, Susan shared an article regarding the unauthorized practice of law. This comment speaks to that. I believe what happens is that the prosecutors refers unauthorized practice of law issues to WSBA. Most cases seem to die there because, as per the article, only 5 cases have been charged since 2004. In addition, for the person charged in the article, he was first notified by the bar to cease his actions in 2007, and it wasn't charged until 2011. The cost to his clients was incredibly high. I have also had to fix paralegals' work, and it causes incredible damage. I remain confused why family law, of all areas of law, was chosen for this pilot foray into the legal practitioners. This may seem like a small law, but the day-to-day effect on the parties is immense, and the danger of permanent damage is high. Gary G. follows up, why family law has been targeted has been the subject of much discussion. It's often viewed with derision by those who fail to understand its breadth and depth. There is some speculation that with the new Domestic Partnership Act and the recently signed Marriage Equality Act, that the court may have some concerns why they would rather not deal with concerns they would rather not deal with down the road. Just reporting the word on the street. Also, those of us who are solos barely making ends meet will have to seriously consider eliminating our considerable pro bono activities when legal tech shops will be opening up on every corner next to Starbucks. Vicky
answer the question that had to do about the area of practice, because that seems to be sort of a topic that threads through there.
Well, I think there are 2 things I'd like to actually address. We can talk about area of practice. The Practice of Law Board looked at 4 different areas of practice, and one of them I think was landlord-tenant, one was immigration, one was family law. I'm not remembering what the 4th one was. Housing, elder law. In any event, they developed 4 subcommittees, and those subcommittees spent a fair amount of time looking at those issues. Actually, immigration law was one that was taken off the table fairly early, I think, because they felt that just didn't fit the legal technician model. But in part, and this may be me rather than exactly what the Practice of Law Board did, but I think as they went through all of this, they were in fact getting a lot of input from family law and feedback, but it was also one of those areas where there was a tremendous amount of need, and so they felt that that was a good candidate to kind of throw up the flagpole and see how they might make it work. You know, I'd invite others who were in it who, you know, saw it from the ground up, but they went through that vetting process before they came to it. And again, I want you to understand that the rule that's before the court doesn't select any practice of law or any particular area of practice. The other thing is the procedures for unauthorized practice of law, and this is where I'll also ask for help if I get this wrong. WSBA does not prosecute unauthorized practice of law. What happens is if there is an issue of alleged unauthorized practice of law, it will end up with the Practice of Law Board. I believe that the Practice of Law Board does on occasion issue letters to people who are practicing improperly, similar to a cease and desist, but they don't really have any enforcement capability. And so the reality is they refer the cases that they think warrant it to the prosecutors. And it's really up to the prosecutors to do something because WSBA doesn't have the capacity, and in fact, WSBA itself does not do it. It's the Practice of Law Board, an independent board, that is making those determinations and then forwarding it on to the prosecutors.
And a follow-up comment having to do with the practice of areas and the fact that the current proposed rule does not have any identified practice areas. As Doug suggested in his preliminary comments, there will be a 13-person board that will preside over the implementation of this rule, I think 9 lawyers and 4 non-lawyers, and it will be the responsibility of that board as it engages in its sort of bylaws and rulemaking or whatever governing documents it has to determine what, if any, practice areas will be identified. So it's a yet-to-be-determined board with a yet-to-be-determined area of practices that will be affected by this rule.
I'm going to start by rereading one of the quotes. I dropped an "un" before authorized, and that changed the meaning significantly. So this is from Mark M. again. I would expect that distinguishing law practice from legal technician service is going to be impossible, practically, in any actual pursuit of the claim of unauthorized practice of law. If there ought to be such a thing as, quote, unauthorized practice of law, close quote, it will become virtually unenforceable, even if prosecuting authorities have unlimited resources. So moving on, Vicky P. says, we need to not do this if we care. Jesus said there will be poor always. We have to recognize that this will not handle the perceived problem. James asks, why go to law school or study to become a licensed technician when you can practice illegally with impunity? Gary follows up, it really seems that this rule is already a done deal, and this, quote, meeting, close quote, is nothing close to a hearing, no meaningful input having been sought or permitted, and it is clear that the trend toward the evisceration of access to the legal system is inevitable. The legal tech rule may be beautifully written as rules go, but it is nothing more than a beautifully written abrogation of the rule against the unauthorized practice of law. Mary H., I still don't understand how the legal technician will be able to work for free. If the focus group that the legal tech is supposed to serve does not have 2 nickels to rub together, who's going to pay the legal tech? Are we really talking about employees of legal services in Washington who get paid by the hour? Christopher M. adds, I'm still waiting for someone to observe that the more apt client choice comparison is not between a legal tech and attorney, but rather between an attorney and going pro se or pro per. Delilah J., why are new and young attorneys being undercut by a state-licensed underclass of legal technicians when there are not enough legal job opportunities to begin with? Vicky P. follows, if they don't come, they don't come. Honestly, set up a full tech system with that as a basis. No. Judith K., I absolutely agree. People who use forms for wills do not have the options explained or offered. They do not get all they want. Also, I agree it is difficult to comment when the areas are not designated. Is that the point of the lack of designation of areas of practice for technicians? This could go anywhere. Someone says, right, Judith, to that. Christopher M. Also, I can't quite get my head around whether the disadvantaged group to be protected is thought to be unrepresented members of the public or underemployed WSBA members.
Those comments appear to be chatting back and forth with folks across the state. I think that's wonderful. I encourage the conversation, but I really want to drop back to a conclusion. This is last call for everybody. Hang on, I'm going to have Jean Cotton, and then the last call will be back to the booth. Going, gone. Jean's the last one. You have a big stack of paper there. You just
it's
get
only
3
because
minutes.
I didn't want to leave in the chair and scare Steve.
All right.
Thank you, Governor Islet. My name is Jean Cotton. I am on the Family Law Executive Committee and have been for the last 11 years. I've been the voice for our section in opposition to this rule, essentially for the last 5 of the last 6 years. I say that because I didn't start out as an opponent. I tried to be a friend. But our voice was not heard. We were ignored. This rule did not come out of the Practice of Law Board simply 5 or 6 years ago. I probably have, I don't toot my own horn very often, but I'm going to for a second. I probably have the single largest compilation of information on this subject of anybody in the state of Washington. This proposal goes back to 1991 when a Blue Ribbon Work Group Task Force of the Bar studied this issue. Judge Procknell from King County was part of that commissioner. And even back then, they realized this would not work, and they recommended against it. They did. They rejected it. And this has come up time and time again. Our board has voted against it twice. Our Supremes have had it tabled now for the last several years. What is concerning to me is most of the lawyers I practice with in family law and in elder law, because I practice in both areas. I'm a rural attorney. We donate of our time more than you can imagine. I started reporting my low bono and pro bono time because of this project back in 2005, 2006, because I never kept track of it before. It was just something you did to help your neighbor. And since this topic has been out for discussion, we've had it on our listserv, and I am finding not just the people that I meet regularly at seminars and at meetings, but also that are on our listserv are all doing the same thing for the most part in my section. Hundreds, if not thousands, of volunteer hours that we give because we care about our clients. We know our area of practice is extremely complicated despite the fact that we have mandatory forms that suck. Okay? We will admit it. We didn't create them. Everybody wants to fix family law. Everybody wants to fix elder law. Why don't you let us fix our area of practice? But we always have to have somebody else do it for us, and then we have to respond. These people that provide low bono and pro bono work, I've heard it here today, I've read it on my listserv this week, are to the point of saying, you know what, you want to authorize non-lawyers and say that all the work that I have done, you know, the 7 years of education and the years of giving doesn't matter. Well, to hell with you. Then I'll stop giving. I don't think that's what we want, and I don't think that's what our Supreme Court wants. I don't see our appellate courts offering legal text to come and practice in front of them. And that's the ultimate solution if somebody screws up at the trial court level. Can you imagine a legal text standing in front of the Supreme Court doing an argument? They aren't even going to be allowed in our trial courts, thank God. But the real issue here is helping the public and providing a service. And in the last 6 years, since this started up again, so many things have changed. The young lawyers have the GAP program. The bar has taken it over now and made it the Moderate Means program. We've got the Home Foreclosure Project. We've had Northwest Justice Office open throughout the state that weren't there 6 years ago, and unfortunately in my county they're pulling back because the money's being cut by the legislature. The economy has hit us all. But there are programs in place that weren't there before, and we're still trying to make better things happen. We've instituted a proposed set of family law civil rules to make our area of practice easier for people to understand, especially pro se litigants. That will be going before our board for a vote in the next couple of months, and then on to the Supremes for review and approval. We've got the plain language forms process in place, and my section is trying very hard to work with those folks. Again, not our section doing this, it's somebody from the outside. We've asked time and time again for the bar to consider a method of giving CLE credit or something in return for pro bono service, especially for folks that have law student loans that have to be repaid. I may be 57 years old, but I've only been practicing for about 19 years. This is my second career. I too have law loans. I have to pay my bills just like every young lawyer out here. And so will these legal techs.
Okay.
I was really happy to hear Mr. Williams speak.
Jean, we've got a bunch of people in the queue, and you're at 5 minutes, so I'm just going to give you a couple seconds to wrap up.
I will wrap up as fast as I can. I started out as a paralegal too, and I thought I knew everything and could go out and change the world. And then I went to law school and I found out how much I didn't know. And I don't know a paralegal alive that doesn't think they don't know it all. We need to take this to our Supreme Court and let them know that we're in opposition. We've given $1.5 million to civil legal need. We've already spent $1 million on the Practice of Law Board. I think it's time our dues went to protect us.
Thank you, Jean, very much. All right, now in the booth, if we could maybe limit the chit-chatty part of it to, you know what I'm talking about? The folks in the room don't get the benefit of having this, chit-chat stuff going on. So if you could maybe synthesize the comments into something that's going to be less that.
Okay, I'll do my best.
I know you will.
So let's start again. That Kristen adds, why not give some incentive for lawyers to work for less money in some cases? What is going on with unbundled legal services in Washington? That could be a partial solution. Actual lawyers helping clients with all of the things a legal tech could under this rule, but on an a la carte basis, rather than having to be, quote, attorney of record, close quote, and then being trapped in a case with a difficult or non-paying clients. Gary G. says, but attendance at the live meeting was limited and the timing is midday, when those of us who really have to work to earn a living could not possibly attend. There are numerous problems with both the concept and the proposal. One minor one comes to mind. If funds are in such short supply, where will the money come from to design, administer, monitor, manage, police, regulate, and ultimately report on and then adjust the rule, the program, etc.? Also, when was the last time anyone on this committee or the court had to actually utilize the services of a graduate from a paralegal school? After 2 years, for example, at Highline's paralegal program, which I understand is excellent, a paralegal I know advised me he had not even heard that there was such a thing as family law forms. Looks like Pete Karadimas says, it's obvious that specific areas of law are omitted to prevent specific sections from commenting. Once rule is passed, most areas will be on the table. This one's interesting from Christopher M. For better or worse, it's probably the way the world is going. In medicine, physicians supplemented by physician's assistants and nurse practitioners. In Canada and the UK, the choke point for attorney and solicitor supply is the limited supply of articling slots, just as it is for medical students who can't get residencies. Vicky P. adds, it's not necessary for the practice of law to go the way of the world is going. Physician assistants and and nurse practitioners pretend they're doctors and make serious errors. One nearly killed my father and me. We don't need to hurt people and their issues by authorizing this. Delilah J., this is not the same as the MD DO, and I'm not certain what a DO, versus a PA, a physician's assistant, or a nurse practitioner. There is a reported shortage of medical doctors in primary care. There's no reported shortage of licensed attorneys capable of doing legal work. There is a shortage of paying jobs for lawyers doing legal work. And since law school is not free, nor are annual law license fees and CLE required credits, it seems very unfair to have non-attorneys approved to do legal work. And I am at the end of my...
Okay, good, because we're just at the 4 o'clock hour.
So it looks like there are more coming in, but I haven't...
Since I told folks they had until 3:30, perhaps we won't have a chance to read all of those. There were a couple of comments that I want to just respond. The Bar Association does have a moderate means program. It is up and running. It is accepting clients, I believe, in most locations. It is taking applications from lawyers to participate on those panels. So if anybody's within earshot of my voice, either in the room or on the web, please make sure to sign up for the Moderate Means panel. We need the help, and it's a very good program, and you actually get clients and offer your services at a reduced price with those folks. I'm going to give the folks in the booth 2 more minutes, and then we're going to wrap it up.
All right, thank you. So, let's see. I'm going to start with Brian. It seems that several writers or speakers have read the proposal. The proposed rule would safeguard the public by regulating the practice of legal and law-related services by licensing limited licensed practitioners and requiring them, among others, to be held to the same standard of care as an attorney pursuant to the RPCs. The relationship between an LPP and their client would be governed by all rules and considerations that govern the relationship between lawyers and their clients. LPPs, in fact, would have to meet higher standards in some aspects. Brian goes on, until pro bono work made it mandatory, pro bono services by attorneys alone will never fill the unmet legal needs identified in the study. The argument that some attorneys are having a difficult time making financial ends meet and can't stand the potential competition of a handful of new service providers is almost comical. What about the hardship of those persons who have no help navigating a complicated legal system without any guidance? Don't their needs matter too? New LPPs would have to demonstrate their financial ability to defend claims. If there are some bad apples, the new law will be for the first time provide the teeth to stop the UPL by unqualified and unlicensed individuals. I suggest we proceed with a pilot program in one area of law, test it, tweak it, and then decide if it is helping or hurting overall. The current situation is currently not meeting the need, so now is the time to try something new. And I'm told there's one more coming in. Let me...
Last few comments. I've never participated in this room with the webcast, even though I live in Spokane. And I just have to give a compliment and a shout out to the folks who run this facility. It's exceptionally well run. Thank you very much. I like that folks from outside Seattle and the I-5 corridor are able to participate in this in real time and have their comments heard and considered, as well as anybody who's able to walk down the street or drive down the road to come here. So the WSBA made a smart move a few years ago to invest in this facility. I'm very proud of it.
I have one more comment that I would like to read because they have asked me not to skip it. And I would also like to note that we have someone from as far away as Miami, Florida, online. So,
go ahead.
So, why family law has been targeted has been the subject of much discussion. It's often viewed with derision by those who fail to understand the breadth and the depth. actually think I've already read this. So, so I'm going to finish reading it again. There is some speculation that with the new Domestic Partnership Act and the recently signed Marriage Equality Act, that the court may have some concerns they would rather not deal with down the road, just reporting the word on the street. Also, those of us who are solos, barely making ends meet, will have to consider seriously eliminating our considerable pro bono activities when legal tech shops will be opening on every corner next to Starbucks.
Miami?
That was not from Miami. Those were two different comments. I'm sorry.
All right. Has the person from Miami said anything of note?
I actually didn't keep track of that, I'm afraid.
Okay.
I just asked early on where folks were.
All right. I was going to say, I'm glad that we've gone live national. That's fabulous. Two more? All right. That's it. Two more, and then we're done.
So Gary says, how about requiring large firms to hire competent, seasoned solos and pay them a living wage and designate them as a pro bono attorneys for family law matters? Lisa Seifert says, yes, thanks so much for the technology assists for us out-of-towners. No need to read this comment.
All right, I couldn't have ended it any better with that one. Thank you so much to everyone across the state who's participated via the webcast. We appreciate all of your comments and your good sense of humor as we conclude this town hall forum on a very important piece of information for our members and for the court. Thank you to everybody in the room. Thank you to the bar staff who put this all together, and the folks in the back who makes it all seem very seamless. We will be collecting all of this and, like I said, posting it on the website on Monday and transmitting it to the Supreme Court for their consideration. Thank you all very much.